All right, we're on the record on State versus Loyd. Mr. Loyd is present with his attorney. State Attorney's Office is present. Mr. Loyd is wearing a long-sleeve black civilian shirt buttoned down. He's got on civilian pants. He's wearing jail shoes and shackles. His feet are underneath the table and cannot be seen by the jurors from any angle in the room. All right, we're missing a few jurors, but I'm going to go ahead and start without them. Let's go ahead and start lining them up.
Jurors, would everyone please stand, raise your right hand, face the clerk to be sworn, and answer out loudly for me, please.
Do each of you solemnly swear that you will answer truthfully all questions asked of you as prospective jurors on behalf?
Have a seat, folks. Good morning, everyone. Welcome back. I hope you had a nice weekend. Can you all hear me with this mask on when you're up here? All right, I've got somebody already is giving me the squint eye. Can you hear me now? Yeah. Okay, all right. For the record, I've removed the mask since the jurors cannot hear me. All right, you're back for day 2 of questioning here. As I told you, today is individual questioning. You're going to start as a group. I'm going to give you some instructions, and I'm going to give you some additional information about this case. Then we're going to bring you in one at a time and ask you some specific questions about certain topics. I'll tell you about that in a minute. Let me start by giving you a little bit more information about this case. In this case, Mr. Loyd has been charged by indictment with several counts. An indictment is a piece, this is it, this is a copy of the indictment. It's essentially pieces of paper that we give someone that tells them what they're being charged with. You have to tell people what you're accusing them of doing. Florida does it by indictment in these cases. Indictments are not evidence of guilt. You can't use them as evidence of guilt. In other words, when you're trying to decide whether or not the state has proven that Mr. Loyd is guilty, you can't use the fact he was charged. You can't assume just because he was charged he was guilty. This is just telling you what he's charged with. In this case, Mr. Loyd is charged in count 1 with first-degree murder with a firearm of a law enforcement officer, count 2, attempted first-degree murder with a firearm of a law enforcement officer, count 3, aggravated assault with a deadly weapon, count 4, carjacking with a firearm, count 5, possession of a firearm by a convicted felon. These cases, as I told you, this is a death penalty case. The first count, first-degree murder of a law enforcement officer, is a count that makes this a capital case. And by capital case, we mean a case in which the death penalty is a possibility. As I've told you before, we do not have mandatory or automatic death penalties in the state of Florida for any case. It's just a possibility. So the case is tried in 2 stages. The first stage is the guilt phase. The guilt phase looks like every other criminal trial that you may have ever sat in as a juror or seen. Not on TV. The ones on TV aren't really real. But the guilt phase of the trial is where you all are asked to determine whether or not Mr. Loyd is guilty. So your job in the guilt phase is to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all counts, meaning each juror must agree on each count either to acquit or convict. The burden of proof for the state is the same in the guilt phase of a capital case as it is in every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you receive on reasonable doubt will be exactly the same as the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence in this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other of the offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. Now, phase 2 is the penalty phase. And if and only if the jury returns a verdict of murder in the first degree, the jury then reconvenes for the penalty phase for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. Life imprisonment without the possibility of parole in the state of Florida means exactly that. The defendant will die in prison. We do not have parole in the state of Florida. If you are in a penalty phase, a special set of rules and instructions come into play. As I told you before, at each stage of the proceedings, I will give you instructions, specific detailed instructions, jury instructions in the guilt and penalty phase are in writing. But right now, I'm not going to give you those. I'm just going to give you an overview of what a penalty phase is like. The death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree. So the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty. So they created a list of circumstances which juries are to consider in reaching a verdict in a penalty phase case. In a death penalty case, I'm sorry. The circumstances are this. For the state, they're called aggravators. They're limited in number by statute. There are 16 of them by statutes. The state is required to prove these aggravators, these factors, beyond and to the exclusion of a reasonable doubt. They must prove at least one aggravator for the death penalty to become even a possibility as a sentence in a case. The defense has mitigating circumstances. Mitigating circumstances are the reasons the defense believes that life in prison without the possibility of parole is the appropriate sentence in this case. Mitigating circumstances do not need to be proved beyond a reasonable doubt. They need only be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters relevant to the defendant's background, character, or the circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without parole. Before you may vote the court impose a sentence of death, the state must prove at least one aggravating factor beyond a reasonable doubt. Once all the evidence has been presented in the penalty phase, you then retire, and I give you the law, which is the jury instructions. You retire to the jury room, the same one you all have been sitting in with your fellow jurors, to consider your verdict. You are then asked to weigh the aggravating factors and mitigating circumstances to determine the proper punishment. This is not a mechanical or mathematical process, and by that we mean you are not there to add up the number of aggravators, add up the number of mitigators, and say this side wins. That's not how you do this. The law contemplates that different aggravators or mitigators may be given different weight or values by different jurors. In your decision-making process, you individually and you alone are to decide what weight to be given to a particular factor. Each juror may give whatever weight they determine to each aggravator and each mitigator. Regardless of your findings in this respect, however, you are never compelled to nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you, after weighing the aggravators, the mitigators, discussing the case among yourselves if you wish, taking a look at everything you've heard, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, the vote to sentence someone to death must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, this is just intended to give you a broad outline of how a penalty phase goes. Since none of you have any experience with it, as I said, we'll give you detailed instructions at every step of the case. Let me also say this. the fact that I'm talking about the death penalty is not to be taken by you as any indication one way or the other as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing it because it's a possibility. It doesn't presuppose anything. We just have to be ready in case it happens and know that you are able to do your job as a juror in both phases of the case, both guilt and penalty. Now, we're going to be asking you some questions on a variety of topics this morning. I want you to think about them while you're in the jury room, because these probably are questions that nobody's ever asked you before. And they are as follows. Number one, we're going to ask you what your position is on the death penalty. We are going to ask you if you have a religious, moral, or personal objection to the death penalty, whether you are someone who could never impose death regardless of what the law says. On the flip side of that, we're going to ask you if you're someone who believes that if someone is convicted of first-degree premeditated murder, the intentional killing of another human being, they should automatically be sentenced to death. As I have told you, Florida does not have an automatic death sentence for anyone or any type of case. We're going to ask you whether you believe you can fairly and openly listen to the evidence from both sides in a penalty phase and go back there and fairly and calmly weigh the aggravators and the mitigators and reach a verdict. Many people have very strong feelings about the death penalty, both for and against it. The fact that you have such feelings does not automatically disqualify you to serve as a juror, as long as you're able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. We are also going to be talking to you about a defense that Mr. Loyd has raised. In this case, he has raised the defense of not guilty by reason of insanity. I'm going to read you, there is a jury instruction on that. I'm not going to read you the whole instruction. I'm going to read you the definition right now, and then we are going to be asking you about your feelings and beliefs about this type of defense. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. As I said, we're going to be asking you about the insanity defense. Lastly, I'm going to read to you a statement of the case. These are not evidence that I'm reading to you. I'm just reading you a statement of the case because we need to ask you some questions. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019 and ended on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. The portion about the conviction for the murder of Sade Dixon and her unborn child, she was pregnant at the time, and the life sentence without the possibility of parole cannot be used by you to determine guilt in this case. In other words, this is a completely different case, and just because he was convicted of that, you can't assume he's guilty of this one. We're going to be asking you questions about your ability to put that out of your mind in the guilt phase of these proceedings. These facts would be used later on in the case, and I would instruct you as to how you can use them, but you cannot use them to determine guilt. So before I send you back into the jury room, I have a basic question for you all. Just raise your paddles for me. How many of you have heard about this case? Raise your paddles if you have. So I've got, once I tell your name, you can put them down. 8, 13, 25, 31, 32, 33, 35, 39, 44, 48, 49, and 55. Of those of you who raised your, did I miss anybody? Of those of you who raised your paddles, how many of you have formed an opinion as to whether or not Mr. Loyd is guilty? 13. Anybody else? 44. Anyone else? All right, thank you very much. 13 of you will stay in the courtroom. The rest of you return to the jury room. I'll be with you as soon as I can. There should be coffee back there. Feel free to help yourselves. They can have a seat. I'll get to them when I get to them. They're going to be the, yeah, which ones are they? Okay, and 7? Okay, I'll instruct them separately at the end. They're just going to have to wait. I'm going to take the folks who came on time. Um, 44, you need to go back in the jury room. Sorry, yeah, you need to go back, yeah, thanks. All right, good morning.
Morning. Morning.
There aren't any right or wrong answers to the questions that we are asking you. We're not really looking for a particular answer. We need you to tell us the truth and tell us how you actually feel about this, all right? How much of, well, first of all, where did you get your information about this case?
The news.
The news?
Yes.
Local news, the internet, what are we talking?
Probably all of that.
All of them?
Probably both of that, yeah.
Facebook?
Maybe. I don't know. It's been a while.
Have you had conversations with anyone about the case?
Sure, yeah. In the past, I mean.
Yeah, in the past, yeah.
Absolutely.
So tell me what you heard about this case, as much as you can remember.
Well, I remember it pretty vividly. I mean, I've lived in Orlando for many years, so I remember when it happened. I remember the I remember that when that happened. I remember the Walmart incident. I remember the fear in everybody in the news and everything during that week after that happened. So it's pretty vivid. I mean,
All right. So are you pretty much a regular consumer of news?
yeah. Mm-hmm.
All right.
Yeah.
Based on all of that, the conversations, what you saw, anything you may have read, did you form an opinion as to whether or not Mr. Loyd is guilty?
Yes, absolutely.
And what is that opinion?
Guilty. Yeah.
Jurors must be able to begin this trial presuming that Mr. Loyd is innocent. Do you believe that you can set aside your feelings, or do you believe you would presume he was guilty?
It would be really hard for me to put aside my feelings on that.
All right. Thank you, sir. Any
Yes, ma'am.
objections from state?
No, Your Honor, we move.
Defense? All right. All right, sir, thank you very much. This isn't the case for you. You are excused.
Okay.
You're
Thank
free
you,
to
ma'am.
go about your business. You can keep that mask. I know you're excited. Juror in seat number 44, please.
Halfway down.
Good morning.
Good morning.
I have a few questions for you. There aren't any right or wrong answers to these questions. You just need to tell us the truth, okay? You said that you knew something about this case. What do you know?
Well, during the initial, I guess the initial arrest part that was going on, I have a long commute to work. I listen to the radio a lot. It was being discussed on the radio a great deal. Specifically, something that was not brought up by you. I remember specifically, and I might be getting some of the titles wrong here, But I remember specifically that the state's attorney originally decided not to seek the death penalty, and that I'm not sure if the state's attorney was replaced or it was taken out of her hands. But then the death penalty was sort of reinstated as a possibility as a result of that. And so that there was some politics around whether or not the death penalty would be involved with that. And essentially what was involved with the media coverage.
Did you watch it on the news, read it on the internet?
I've seen it on the news.
Okay.
I'm a college professor. I stay up with current events and local news as well.
I was going to ask you, are you a pretty regular consumer of news, of local news?
Yes.
All right. Did you see or hear anything on Facebook or Instagram or any of that?
I'm sure somebody shared a story, but I mean, this was years ago. So. Was
this something that was being talked about among your family, friends, or colleagues?
Yes. As a college professor, some of my students were discussing it.
Right. So based on everything that you've heard, read, discussed, have you formed an opinion as to whether or not Mr. Loyd is guilty?
I could weigh the evidence. I could sit and take a look at the evidence. I could do that, but I think I have an opinion on it already based on what I know. That he would be guilty of it.
Okay. In order to be able to sit as a juror, you have to presume he's innocent. You can't assume he's guilty but wait to see if he can prove he's innocent. It's got to be the other way around.
Right.
You have to assume he's innocent. Can you do that, or do you think you're going to be sitting there thinking, I really think this guy's guilty?
I could presume innocence. Everyone has that right, and I could do that.
Okay. So let me present you with some scenarios. You tell me if any of these apply to you. Number one, you're seated as a juror and you're going, I think this man is innocent and the state needs to prove to me beyond a reasonable doubt that he did this. Number two, I think he's probably guilty, but I'm willing to listen and see if I'm wrong and he's actually innocent. And number three, I think he's guilty, but I'll give him a shot and see if he can convince me. Do any of those three apply to you?
Number two right now is probably the most accurate scenario.
Okay, thank you. State?
We move, Your Honor.
Thank you. All right, sir, this isn't the case for you, but we appreciate your willingness to serve. I'm going to excuse you as a juror in this case. You're free to go about your life.
Oh, okay.
Thank you.
Thank you, Your Honor.
Let me have the juror seat number 8, please. Juror 118. Good morning, ma'am.
Good morning.
How are you?
Good.
Welcome back.
Thank you.
All right. As I said, we have a few questions for you. I need you to be very honest with us. There aren't any right or wrong answers to these questions. What we're looking for is to find out what you actually think and believe.
Okay.
So it's very important that you just tell us the truth, all right? Let me start with, you indicated you knew something about this case. How did you get your information about the case?
Honestly, I don't know much about it. I heard my boyfriend and his brother talking about it long ago. So the first time when I heard the name, I was like, oh, that's probably what they're talking about. So that's as much as I heard about it, and I kind of saw it on TV while I'm getting my kids ready there, but honestly, I did not really pay attention.
Okay. Do you remember what it was your boyfriend and his brother, you said? Or his friend?
Yeah, his brother.
What they said?
They were saying that basically there was another cop case, there was a shooting, and so I'm not even sure they were saying there's another cop case or they were actually talking about the defendant. I just remember them mentioning a cop and a shooting. And I was like, okay. So I just didn't really pay attention.
Okay. Is either one of them a law enforcement officer?
No, they're not.
Okay. Is there anything about the conversation that you overheard? So let me back up a minute. I'm sorry. Did you read anything about the case?
Not really, no.
Facebook, anything like that?
No.
So when you say not really, does that mean no, you didn't?
No, I did not read. Like I said, if people were talking about it in the background, I just kind of moved on because I really had no interest on the case itself.
So based on everything you may have picked up just in the background, did you form an opinion as to whether or not Mr. Loyd is guilty?
Not at all. I don't know. I don't have enough information.
All right. So let me ask you, what is your position on the death penalty?
I don't believe in it, but I know I wouldn't be making the decision. I just don't think that somebody should be punished for allegedly doing that with the same thing that they're being punished for. Does that make sense?
What makes you think that you wouldn't be making the decision? That's exactly what you're doing.
But it's based on logic. It's based on the facts that we have. I'm not saying, hey, this should be because I think that way. We're just putting the facts and you're telling me whether yes or no. So it's not coming from me.
All right. So are your beliefs about the death penalty religious, moral, or personal?
Moral.
Moral. How long have you had those beliefs?
Forever. Always.
Right, you heard me explain to you what happens if Mr. Loyd was convicted of first-degree murder. It's premeditated murder, the intentional killing of another human being. If that happens, there's a penalty phase. The state's going to present to you aggravators, statutory factors that they believe should result in a vote for the death penalty. The defense is going to present the mitigators, reasons that they believe the vote should result in a sentence of life without the possibility of parole. You have to be able to fairly and openly consider both options. And so when you go back there and you're weighing aggravators and mitigators and everything that went on in the case, everything that you heard, if at the end of that you believed that the law and the facts, the aggravators and mitigators led you to that the appropriate sentence was death, would you be able to vote for death?
I'm not sure, to be honest with you.
Okay.
I would like to tell you yes or no, but given at that moment, I don't exactly know how I would react because I never had to make any decisions like this, so I wouldn't know.
And I understand, but the problem is that at this stage of the proceedings, both sides have a right to have their information heard fairly and with an open mind, not I'm going to sit here and listen and then I'm going to vote for this or that. That's not what an open mind means, and we need to know that jurors are able to do this. So take a minute. Think about it, kind of put yourself in the situation. You've looked at everything. You've looked at the instructions I've given you. You've weighed the aggravators and the mitigators, and you believe that everything leads you to voting for a sentence of death. Now, you're never required to vote for death. I understand that, but you have to be willing to at least consider it. Do you believe you would ever be able to vote for a death sentence?
Yes, I could, potentially.
Eventually?
Potentially.
Oh,
I'm just
potentially,
saying, yeah, because there's very strong things I had about things like abortion and stuff, but when you're put in the situation, everything changes. So I think that will go in this case too. I say, yeah, I don't think it's right, but being put in a situation and being presented, if it's both, then I believe I can make the most logical decision.
Okay. Do you have any doubts about your ability to do that?
No.
You heard me explain that Mr. Loyd has raised the defense of not guilty by reason of insanity.
Correct.
The defense has to prove that. It's in the guilt phase. It's not in the penalty phase. It's when you're trying to decide whether he's guilty or not. It's the only burden they have in the guilt phase. Otherwise, the state has to prove him guilty beyond a reasonable doubt. You'll get all these instructions in writing, okay?
Okay.
So let's say that it's the end of the guilt phase. You've heard all the evidence and you believe that they have proven it. It's by clear and convincing evidence. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Right. And then lastly, you heard me tell you about the conviction for the murder of Miss Dixon and her child, her unborn child. Can you put that out of your mind in the guilt phase? You can't use that to determine whether or not he committed these crimes. You understand that?
Yes.
Can you do that?
Yes.
All right, thank you so much. I don't have any other questions for you, but the lawyers do. All right, so sorry, you're not off the hook yet. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
So when I was listening to you discuss the death penalty with the judge, you said at least a couple of times that you could use logic and that logically you could go through that process. And I was interpreting that as you saying that you could separate logic from your emotions.
Yes.
Is that what you were trying to say?
Yes.
Okay. which leads me to believe, and again, if I'm wrong, tell me, okay?
Okay.
That emotionally, and I think morally, you said that you have an opposition to death.
Correct.
Okay. Explain that moral opposition. I think I know, but I don't want to assume what's in your mind. What is your moral opposition to the death, in a vacuum, what is your moral opposition to the death penalty based upon?
I don't, like, we shouldn't decide whether we should take somebody else's life or not, but at the same token, if somebody else is making that decision, then I guess, like you said, it's kind of like every kid. You know, some kids you have to hit for them to behave and some you don't.
Right.
If they're making the decision that it's okay for them to do it, in that sense, logically, okay, well then you would take the same sentence. Does that make sense? You're taking somebody's life, then maybe that's how you need to be punished, logically. Now, morally, I'm like, well, we shouldn't really decide whether or not we can take a life, but then they made the decision too. So it just, morally, I'm like, no, but logically, if they're using that as like a weapon or a way to decide something, then maybe they should have the same, we should use what they thought it was okay when we're looking at them.
Okay, so, no, and that makes, I think I understand what you're saying. So, you're going to be told a lot about the death penalty. Make sure this is on. Can you hear me okay?
Yes.
Okay. The instruction is long, and you do get a substantial amount of guidance from the law as to when a sentence of death is appropriate, an appropriate recommendation, and when it's not. But as the judge alluded to, the law compelled or required. Does that make sense?
Yes.
So, under no circumstances will the law tell you that you must vote to impose a sentence of death. So what I'm sort of struggling with, given your moral position, is given that logic and the law will never require you to make that decision, could you make it, given your moral opposition to the death penalty?
Oh, I see what you're saying.
Yes, ma'am.
Okay.
Because it's not, you're sort of, my interpretation of what you're saying is if the law says it's appropriate, then logically I could set aside my moral obligation. But I'm telling you right now, the law is never going to require you to vote for a sentence of death. You will always have the option to not vote for death, to vote for life, because that is your moral judgment. In fact, that decision, that ultimate decision, has been characterized as a reasoned moral judgment. So the first part is what you're referring to, reasoned. The second part, the moral part, is where I'm sort of wondering how you could reach that decision, the ultimate decision, knowing that you would never be required to do that.
Yes. However, in this case, they're saying that the decision is not so much that I'm saying, oh, this person deserves. It's basically saying, hey, this is what we have, this is what it is, this is what we think. Which one do you pick? That's how I see it. So it's not me making, oh, this is going to happen, and I think that because of my morals and whatever else is going on, I'm going to go with this. It doesn't, I wish it worked like that sometimes, it's just that easy, but it's not. When you're presented with everything that's in there and they're asking you to look at that logically, and I understand we're not required, as far as like morally to put a decision, but we are required to pick A or B over here on this side. Like at the end, we are required to say, hey, and have an open mind to see, hey, this is something based on this logically, this is something that's on the table. Based on this, what would you do? So I don't think it's really making me specifically decide what's going to happen to the person. It's saying, hey, pick from the options A and B because this is what we have.
Okay.
So I think morally, and the only reason why I think is for me, because like I said, when you believe something and when you're presented with the evidence and the position in there, then you really have to, you're forced to look at the facts and okay, yeah, I've been raised to believe all this all my life, but this is what I have in front of me. Based on this, then you make the decision, which is what I think, the trial is for. You have to let all that aside and just look at what you have in front of you. And I understand sometimes it could be difficult, especially because I have my morals and things like that, but I think there's a big difference with what you believe to believe in who the person that you are and just making a decision on something that you have in front of you.
So what I'm hearing you say is that you could set aside your moral objection.
Yes.
And make a decision based on the law and what was presented to you about this specific case.
Yes.
Even if that decision ultimately you believe that a death recommendation was appropriate.
Objection, use the word recommendation.
Overruled.
I didn't hear it, Judge.
You need to speak.
Use the word recommendation.
Overruled. Go ahead.
You can answer the question. Do you need me to restate it?
Yes, please.
Sure. What I hear you say is that you could set aside your moral objection, any moral objection you have to the death penalty, and make a decision based only on what you hear and the law and the guidance it gives you, and that if you believe that death were appropriate, you could vote to make that decision. You could vote for death for another human being. Do I have that right?
Yes.
Okay. Any concerns about your ability to do that?
No.
Okay. That's all I have, ma'am. Thank you so much. Thank you, Your Honor.
Thank you. Ms. Miller, you may inquire. No. You can do it afterwards. Let's go.
Good morning.
Morning.
Just a couple follow-up questions
Yes.
for you.
Is your microphone on?
It is.
No? Is it? Okay. Go ahead.
Can you hear me okay?
Yes.
Okay.
Thank you.
Because death is never required in any case, not in this case, not in the worst imaginable case, the standard for a juror to serve on a case where death is a possible penalty is that the juror be able to give meaningful consideration to possible penalties. Life in prison without the possibility of parole or the death penalty. And you can do that, correct?
Yes.
Okay. No one's signing you up or requiring you to give a death sentence in any case, let alone this one. With me?
Yes.
Okay. So I want to back up, right? You heard the judge ask if you are somebody who thinks that death is automatic or should be the automatic penalty once someone is found guilty of first-degree murder, right?
Yes.
I just want to make sure we're on the same page. Murder, first-degree murder in Florida, is the intentional, premeditated killing of an innocent human being. That defendant thought about it, meant to do it, and did it. With me?
Yes.
If a jury found somebody guilty of first-degree murder, that jury in that first part of the trial, as the judge discussed, would have considered any available defenses, things like self-defense, and would have rejected any of those defenses in finding that person guilty of the intentional, premeditated killing of an innocent victim. With me?
Yes.
So we're talking about killing without any legal justification, excuse, or defense. So understanding that, is death the automatic penalty for a totally intentional, unjustified killing?
No.
Okay. Why not?
Why would it be? Like, there's many options to that, right? Like, I understand that's what they decided to do and what they had in their mind to do it, but maybe for somebody, the punishment shouldn't be the same as the death penalty. Maybe it should be something else. Maybe it's life in prison with parole. But without knowing all the facts, how would I know what would be the best option? I wouldn't know.
Okay. Let me add one additional factor, right? We're still talking about the killing of an innocent, intentional premeditated killing of an innocent victim, but the victim is a law enforcement officer. Should death be the automatic penalty for somebody who intentionally kills in an unjustified way a law enforcement officer?
It would be the same answer, because it doesn't matter if it's a law officer, whoever the other person is, it's still a person.
Okay. And then the last sort of factor I want to add to that is somebody who's guilty of the intentional premeditated killing of an innocent victim who is a law enforcement officer, and that person has previously been convicted of another first-degree murder and is already serving life without the possibility of parole. Is death the automatic penalty for this murder?
No.
Why not?
Again, whatever has done, the punishment that they give them maybe wasn't enough, but that doesn't automatically mean that they have to go to the death sentence.
Okay, those are the only two options. right? Life without the, for first degree murder, life without the possibility of parole for the death penalty. And so when you say that might not have been enough life, the only other elevation in penalty is the death penalty. You see what I'm saying?
Oh, okay. And honestly, if people that know more about this, if they decide that that's the punishment for that, then that is the punishment. I think, is it my decision or like the jury to decide whether they're guilty or not, correct? Or we're deciding what the punishment is as well?
No, that's 100% the jury's decision. So the jury would make the decision of whether or not this defendant is guilty, right?
Yes.
And then if, and only if, the jury decides the defendant is guilty beyond a reasonable doubt of first-degree murder, we go to the second part of the trial. And all 12 jurors in the second part of the trial have to come to an individual moral assessment about whether that defendant lives or dies. It's your call. And so the judge is going to give you guidance about what the law and the legislators have said, you know, as to what cases the lawmakers have decided are appropriate for the death penalty, but it is your call as a juror whether life or death is the appropriate penalty.
Okay.
With me?
Yes, I'm with you.
I think that's what the state and I were both trying to figure out, because some people say, you know, I hear the law and I want to follow it, but for me, I'm just not going to be able to do that. And it sounds like you're somebody who would be able to do that.
Yes, like I said, that's not my forte. So if you're telling me, hey, we're going to give you guidance and we're going to tell you what this is, then I'm just going to follow the guidance that I have in front of me.
Okay, let me give, so the guidance is, if we're in the second part, right? So the first part is, has the state proven beyond a reasonable doubt the defendant is guilty of the crime of capital first-degree murder, right?
Correct.
Only if that answer is yes do we get to the second part of this trial, okay? And then at the end of the second part, the sentencing phase, you have to decide with the jury, did the state prove the existence of at least one aggravating factor beyond a reasonable doubt? Is that aggravator sufficient to warrant the death penalty? Does that aggravation outweigh mitigation? And then the last question is death the appropriate penalty? And that's where the answer is never required to be yes. Even if you're like, yes, 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 you still never have to vote for the death penalty. So the law can't tell you what your verdict should or should not be. Does that make sense?
It makes sense.
So it gives you like a step-by-step of how we even get to whether or not we can consider the death penalty, but it doesn't tell you the right or wrong answer. There is no such thing.
Yeah, so you're saying basically even if they present everything, they're guiding me to do that and everything says yes, I can still look and say, well, I don't think he deserves it.
Exactly.
Yeah, for me to make a decision like that, I will obviously really like to know what's going on, but I think that I can say yes or no based on what I see or the guidance that I'm given, because I have to have an open mind. If it is a consideration to have the death penalty, I have to have the open mind and say, okay, well, this is the case, let me hear what they have to say about it. And I also, like I said, and also from what I guess I was going to believe, maybe there's another chance. So I'm going to have my ways. I can say yes, I can say no, but I think if I have all the information in front of me, have the guidance, I can say yes or no either way based on what I see and what is presented to me.
Okay. You said, I would really like to know all of what's going on.
Correct.
What does that mean?
Well, somebody can tell you one, like they say there's three sides to every story, right? One tells you one side and one actually happened. And you can look at something and have completely different views. Like we can see, like if my daughter falls, my sister is going to have a different story than I have because she's looking at it from a different perspective. Until you know everything or everybody's point of view, then you can be like, okay, this is what happened. So I think to make any decisions at all, whether guilty, not guilty, death penalty, or anything, you need to see everybody's point of view and see what really happened for you to be like, okay, then you can assess what you think is best. Because without knowing, you can tell me here, oh, they did this, great. But you don't really know what's going on. You don't really know what's going on in the person's head. You don't really know, you're not there. So I cannot make a decision based on, oh, they said that he was guilty, then does he deserve this? I don't feel comfortable jumping to a decision like that because you never know what happened. Like, you never know what happened. And so that's what I mean. Without knowing all that and without having all the information, I can't tell you yes or no because I really don't know. And I wouldn't feel comfortable when I'm telling you yes or no because I don't have the information.
Right.
And I like to know as much as I can to try to understand. Like, I'm the kind of person that I'll put myself in everybody's shoes, just trying to see where everybody's coming from. And I'm like, okay, well, and then I can make a decision. So that's what I mean. I would like to know everything because I don't know what everybody's thinking. I wasn't there. I don't know. I have no idea. And as said before, I really don't know much about the case.
Right. That's how it should be, right? So folks shouldn't come in here and be like, I can tell you I'd vote life or I'd vote death. We're just trying to get your feelings about the death penalty because you don't know, as you said, anything about Mr. Loyd's case specifically, right?
Correct.
And so you had mentioned that you want to know what's going on in his mind or would like to know what was going on in his mind. You mean the defendant's mind?
Yes.
Okay. And I'm not asking you to list out, like, I think all of these things are aggravating, all of these things are mitigating, but just generally, what type of information do you think you would need to make a decision about life or death?
Objection.
Sustained.
If you had an island, you lived on an island and you were the queen. Yep, you get to make the rules on this island. Would you have a death penalty?
No.
Okay. Recognizing that we don't live on that magical island where you're the queen, you're okay, though, following the laws of Florida, which obviously does have a death penalty.
Correct.
Okay. Let me ask you about a couple things. When we talk about mitigation, it's a legal term, and it literally means why any one person would give life or not give death, okay? As the judge said, aggravation is limited by law to one of 16 things. Mitigation can be anything to anyone. It doesn't have to be unanimous, and it can be even something seemingly small, like a smile you observe the defendant give between a family member. And you could just say, I saw that, not given a death verdict today. With me?
Yes.
Do you think for you, the defendant experiencing the effects of racism, would that be something you'd be able to consider when deciding if life or death is the appropriate penalty?
Yes.
Okay. How about mental illness? If the defendant had experienced mental illness, is that something for you that you'd be able to consider when deciding whether life or death was the appropriate penalty?
Yes.
Okay. And so we've talked a little bit about this. Death is never required. Not in any case, right? So even if we get to the end of that checklist that the law sets out, you can just say, for me today, I'm not imposing a death sentence. With me?
Yes.
And we've talked about mitigation can be anything to anyone. With me?
Yes.
If one juror decides that life will be the penalty, or one juror decides that life should be the verdict, then life will be the penalty. With me?
Yes.
And there's no such thing in penalty phase as like a hung jury. Have you ever heard of that?
No.
Okay, so like in deciding guilt or innocence, all 12 of you have to decide beyond a reasonable doubt if the defendant is guilty or not, right? If all 12 of you in that first part of the trial can't reach a unanimous, and that is all of you agree on the same verdict,
Judge,
then it's a hung jury.
objection.
Sustained. Rephrase the question.
In the first part of the trial, in order for the verdict to be guilty, everybody's got to agree. With me?
Yes.
In the second part, the law requires that each of you give an individual moral assessment as to whether or not the defendant lives or dies. With me?
Yes.
And so it's okay if not all 12 people agree. And if all 12 people don't agree, it's not a hung jury, that's a totally just verdict. Make sense?
Okay. Yes.
And the law requires, in order for it to be a just verdict, that all 12 jurors' individual moral assessments be reflected on that verdict form. So there's only one foreperson who signs and dates and writes down the verdict. But the job of the foreperson is to make sure that each individual moral assessment of each juror is reflected in that verdict form. Follow?
Yes.
And if all 12 individual moral assessments are not on that verdict form, it would be a miscarriage of justice. And so it is your duty and your right and your responsibility to make sure your individual moral assessment is heard in this courtroom. Can you do that?
Yes.
In fact, if you feel like your verdict, you've reached a verdict and it's for life and it's not being respected, you have the right to knock on the door and say, hey, deputy, get the judge. We're done here. I've reached a verdict and we can go home. Can you do that?
Wait, what do you mean? You lost me there.
So like, so one person, if one person says life is the verdict, then life is the verdict. So if one person reaches a verdict for life and people want to badger or bully that person to try to changing his or her mind, you can say, no, we're done. One person's reached a verdict for life, so the verdict's life, we can get out of here. Does that make sense?
Okay, yeah. So I know each of us are individually told like what we want to do, and if somebody has an opinion like that, like that's it, they can just keep that opinion and that's it, like nothing, they don't have to change their mind.
Let me intervene here, ma'am. Let me re-explain this to you. It's not as complicated as it sounds, all right? You're going to listen to all the evidence, and if you get to a penalty phase, you're going to listen to the state present their aggravators. You're going to listen to the defense present their mitigators. You and the jurors get instructions from me on what the law is, on how what you're supposed to do, how you're supposed to weigh this, what you're supposed to look at. So you're going to go back there and you're going to weigh it. You're going to weigh the aggravators and the mitigators. And by that we mean you individually are going to assign whatever level of importance you believe it should be assigned to each aggravator, to each mitigator. It's up to you individually and your fellow jurors. All 12 of you get to decide what's important to you and what isn't. You weigh all of that out. You read the jury instructions. You think about everything that happened in the trial. And at the end of that, you individually reach a verdict, death or life without the possibility of parole, for whatever reason you reach it, all right? It's an individual verdict. You can talk about it all amongst yourselves. So if one of you votes life without the possibility of parole, it's a life sentence. 12 of you have to say, I believe the appropriate sentence is death, for death to become a possibility, for a judge to be able to impose a death sentence. You follow me?
Yes.
Do you have any questions about that procedure?
No.
All right, great. Let's move on.
Sometimes things can get a little contentious, right, where people feel strongly about this, as the judge said. And so you're not somebody who's going to allow somebody else to bully or badger you to changing your individual moral assessment, right?
Correct.
And that's what the law encourages folks to deliberate and hear each other out, right? Which means to carefully consider. And some people say, yeah, I could totally articulate how I've reached this decision. And some people say, I just know in my gut that this is what the verdict is and I can't articulate it. And that's okay too. Okay with all that?
Yes.
May I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further. Thank you.
Thank you. Either side have a motion? You need to approach?
No, Your Honor.
Defense,
No,
you
Your
need to
Honor.
approach? All right. All right, ma'am. You're going to be brought, take this off to make sure you understand me. You're going to be brought back for one more round of questioning. It's the final round of questioning. We will be choosing the jury that day.
Okay.
So, a couple of things. I'm going to change your color dot to purple, so you're now listening when you call the jury room for the purple dot group to return, all right?
Okay.
We do you as colors, as I told you, because there's just too many of you for us to call numbers,
understand.
all right? So, when you hear that you're supposed to return to the courthouse, I don't know when it's going to be, ma'am. It won't be any earlier than the end of this week, and it may be next week. But when you hear you're supposed to come back, you need to pack a suitcase. We're going to give you a packet because the jury's being picked and sequestered that day. So you need to have a suitcase packed and ready to go in case you're picked for the jury. Just leave it in your car. Don't bring it into the courthouse. You won't need it unless you're picked. The package gives you the slip with the number that you're supposed to call to find out whether you're supposed to come back. Don't bother calling before Wednesday, okay, after 5.
Okay.
And secondly, excuse me, it also has a sequestration package. It tells you what it's like to be sequestered, and it gives you some suggested things to pack. Okay? It has a letter also for your employer, or I don't know if you're a student, I can't remember, but either
The
one,
employer,
to let
yes.
them know that you're coming back. Do you have any questions?
No.
All right.
No.
Thank you. All right, you're excused for today. Remember,
Okay.
don't look at anything or read anything.
Okay.
Have a great day, ma'am. Thank you. Okay, let's bring in the juror in seat number 25, please. Sure.
Your Honor,
Yes, sir.
the state objects to defense counsel in any way referencing or interjecting the idea of a hung jury. I objected the first time and then it came back again the second time. It's inappropriate. We would ask the court for an order to both attorneys, for both sides, not to interject that concept.
I agree with that. I'm going to sustain that objection. And even though I overruled the objection, be careful about using the word recommendation. Everyone needs to use the word verdict in referring to death or life. All right, you cleaned it up.
Judge, Mr. Buxman has some argument on that point, if he may.
Judge, I'd cite to you Allen v. State, 322 Southern 3rd, 589, Florida Supreme Court, 2021. In that case, the defense's complaint was that the state in opening statement said, referred to the penalty phase jury decision as a recommendation. The Florida Supreme Court said, taking the statements in reverse order, no error, let alone fundamental error, occurred as a result of the prosecutor's statement that he would ask the jury to return a, quote, recommendation of death because the statement did not improperly describe the role assigned to the jury by local law. Citing Romano v. Oklahoma, which said to establish a Caldwell violation, a defendant necessarily must show that the remarks to the jury improperly describe the role assigned to the jury by local law. The Allen court said, under the plain text of Florida's death penalty statute, a sentencing recommendation is precisely what the penalty phase jury provides.
I missed that case completely. Thank you. I'll take a look at it. All right. Let's bring.
I will not use that language until you've had an opportunity.
Yeah,
to
let me
review it.
read the case and then I'll get back to that. And it'll give you a chance to answer it. Did you get the site?
I did. Do you want me to respond now or later?
If it's brief, very brief. Go ahead.
First v. Florida was decided in 2016 by the United States Supreme Court and found our entire statute to be unconstitutional because the jury was offering a recommendation. And so I understand that that's still vernacular used in the actual statute, but it's still a violation of Caldwell v. Mississippi, a violation of Hurst v. Florida.
Let's clarify this. Hurst v. Florida, the United States Supreme Court case, overturned Florida statute because it was not unanimous and because the court could overrule a life recommendation. At no point did they address the issue of a death verdict being a recommendation and not a requirement. So, all right, we're done. Let's bring the jury in. I'll read this new case, which I completely missed. I didn't see that one. Let's bring in juror number 25, please. I didn't spend all morning on this. Oh, Tariko gets the purple. Good morning, sir. How are you?
I'm fine.
All right. Have a few questions for you, as I said. There aren't any right or wrong answers to these questions. There's just the truth, meaning what you believe and think. That's all we're actually trying to find out. All right, so just answer the question. Don't worry about what your answer is. So let me start with, you said that you'd heard something about this case. Can you tell me where you heard it?
I believe it was on the news.
Okay.
In 2017 when all this was going on. I haven't heard anything since. My wife and I take vacations quite a bit, and that's basically all I remember.
Since that time, do you remember seeing anything on the news or hearing anything about it?
No, I can't say that I do.
Okay. How much did you hear?
Basically, what I remember most was the capture.
All right, tell me what you remember about that in as much detail as you can, please.
That he was captured and lost the use of an eye. Basically, that was it. I mean, I didn't pay a whole lot of attention to it.
Okay. Based on what you saw and what you heard on the news, did you talk to anybody else about it? Like your wife, your friends, anybody like that?
Yeah, my wife and I, we talked a little bit about it, but like I said, we were traveling at that time, and our main focus was on what we were going to be doing.
Okay. Did you form any opinion as to whether or not Mr. Loyd was guilty at that time?
That's an interesting question. My wife and I talk about this a lot. What you see on the news is not enough to form an actual opinion because you don't have all the facts. No, I didn't form an opinion at that time. I just basically, like I said, saw what was on the news and rolled with that.
Okay, and you're absolutely right that what you hear on the news isn't enough to form an opinion on anything. So, but let me ask you this. Did you walk away with an impression as to whether or not Mr. Loyd was guilty?
Yeah, my impression at that time was, well, you know, apparently he did what the news said. But again, that was just an impression, not my...
Okay. The law requires that jurors be able to presume Mr. Loyd innocent until and if the state can prove he's guilty beyond a reasonable doubt. Can you follow that directive?
Yes, I can.
Would you, if you were chosen as a juror, would you start the trial believing, look, as far as I'm concerned, this guy's innocent until the state can prove to me he's guilty? Or would you be sitting there thinking, you know, I kind of think he's guilty, but I'm willing to listen and see if I'm wrong?
No, I'd actually have to see the facts or listen to the facts. Everybody deserves a presumption of innocence.
All right. Thank you, sir. So let me move on from that to ask you, what is your opinion of the death penalty? Do you have one?
I believe in the death penalty.
All right. So you have no moral, religious, or personal objections to the death penalty?
No, I don't.
First-degree murder is premeditated murder. In other words, it's the intentional killing of another person, all right? And in this case, that person was a law enforcement officer. Is there anything about those two things that would lead you to automatically vote for death in a case like this? All right. And as I told you, we don't have an automatic death penalty in this state. Is it your opinion that there are any cases in which, types of cases, not specific cases, in which if a person is convicted of first-degree murder, they should be sentenced to death?
Are there any, what was that question again?
Types of cases in which if a person is convicted of first-degree murder, the sentence should automatically be death with no consideration for a life sentence?
No.
All right. You heard me describe the process through which jurors go through in reaching a verdict of either life without parole or death. Do you believe that you could fairly and openly listen to both sides, weigh the aggravators and mitigators, and reach a verdict?
Yes, I do.
And if the law, the facts, the weighing, everything, your own personal moral code led you to believe that the appropriate sentence was life without the possibility of parole, could you vote for that?
Yes, I could.
And if it led you to believe it was death, could you vote for that?
Yes, I could.
All right, you heard me explain that Mr. Loyd has raised the defense of not guilty by reason of insanity. All right, this is the one time, this is in the guilt phase when you're trying to decide whether or not he's guilty. It is the one time in the guilt phase the defense has the burden of proving that, not states. Defense has to prove by clear and convincing evidence. If at the end of the guilt phase you were convinced that Mr. Loyd was not guilty by reason of insanity, could you reach that verdict?
Yes, I could.
And lastly, as I told you, he was previously convicted of murdering Miss Dixon and her unborn child and sentenced to life without parole. Can't use that in the guilt phase. Different case, doesn't have anything to do with whether he's guilty or not of these charges. Can you put that aside and just focus on these charges?
Yes, I could.
All right, thank you, sir. I don't have any other questions. The attorneys are going to have some questions for you. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
Thank you for coming back as if you had a choice, right? I wanted to ask you about what you saw in the news. What I wrote down was that you did see something about him being captured, him being Mr. Loyd, captured and losing the use of his eye.
Correct. That's what I remember.
Yes, sir. Tell me anything you can, in as much detail as you can, about that prospect. Like, did you hear about how he lost the eye, who was believed to be responsible? Can you tell me about that information?
Actually, I don't remember anything other than what I told you.
Okay, so as you sit, you have no idea about how that happened or what the circumstances were, other than you heard that he lost the use of his eye.
Correct.
Okay.
And as I said earlier, what you hear or see on TV, you're not actually talking to a person who experienced the fact.
Yes, sir.
So.
And was it one story about that you heard?
There might have been 2 days running. I don't recall.
Okay. But nothing more than you can remember than what you've told us to this point.
That's correct.
May we approach, Your Honor?
You may. 1 second, sir.
1
We'll be
second,
right
sir. I'm
back with
sorry.
you.
So I take it from your questionnaire that you filled out, we have your responses, that you're retired?
That is correct.
Okay. And that retirement permits you to take a lot of vacations.
That is correct.
Good for you. Good for you. And do you watch the news pretty regularly?
Actually, we have coffee every morning from 5:30 or 6 to about 7.
I'm sorry,
And-
did you say 5:30?
Yes.
Okay, just
And-
making sure.
And we watch the local news, sometimes Good Morning America, sometimes we switch the channels, but mostly it's background noise. We usually sit just and talk and have coffee.
And we as you and your wife, I'm assuming?
Yes, correct.
Okay. I heard all the responses. I'm going to try not to beat them into the ground. Given your retired status, can you tell me on a scale of 1 to 10 where your desire to participate as a member of this jury is, with 1 being you can't wait to get out of here and get back to coffee with your wife, and 10 being you're very excited about the idea of being a juror? Where would you rate yourself on that scale?
Actually, I'm very excited about being a juror.
And tell me about why that is.
It's my civic and moral duty.
Now, your questionnaire indicates that you've never been a juror before, is that right?
That is correct. I've been downstairs several times, but never been...
Downstairs here in Orange County?
That's correct.
All right. I also wrote down, you said that you believe in the death penalty. Can you
Yes, I
elaborate
do.
on that a little bit for me?
Yes, if... It's complicated, I guess. If a person is proven to be guilty of murder, premeditated murder, they deserve to die. And there are circumstances that say, well, even though the proof is there, death is not the answer. So I believe in the death penalty, but like I said, it's complicated.
Okay, so what I will tell you, I'm going to try to hit the highlights of what the judge referenced as opposed to repeating everything. First-degree murder, the standard or presumptive penalty is life in prison without parole.
Mm-hmm.
I think you heard her say that?
That's correct.
Right. In order for the death penalty to be an option or a possibility, we, the state, has to present evidence of those aggravating factors that she was telling you about. And for purposes of this conversation, those are things that are very much like you would think. So, for example, one that has nothing to do with this case, the victim in the case was a child under 12, right? There are reasons why you can imagine that would be an aggravating factor.
Correct.
Above and beyond a first-degree murder that doesn't have that. But at no point in our law is a sentence of death ever required. So you will be told as a juror that even if the steps that must be proven to you are found by all of the jurors, you are never required to vote for death. Does that make sense?
Yes.
The reason I bring that up is because what I heard you say was if a person takes another life in a premeditated fashion, then the death penalty is appropriate. And that's not the word you used, a different word. I don't remember what it was, but it led me to believe that you thought that it might be automatic.
No.
Okay. So by you saying no, does that mean that you would want to consider the other circumstances around the case before determining that death was appropriate?
Oh, absolutely. Like I said, you need the facts, and then there are circumstances that dictate the death penalty is not the answer.
Right. Okay. So the way the process would play out is once we present evidence of those aggravating factors, if and only if the jury unanimously finds that at least one of those aggravators are proven beyond a reasonable doubt, then you would move on to weighing or to listening and weighing the mitigation. So after we sit down at the penalty phase, the defense will have the opportunity, if they wish, to present evidence of those mitigating circumstances. And that can be anything in Mr. Loyd's life, background, or character, or even about the nature of the offense that they believe is the reason why life is the appropriate sentence as opposed to death. No matter how you feel about the aggravating factors, you would be obligated as a juror to listen, give meaningful consideration to those mitigating circumstances.
Correct.
My question for you is, can you promise us that you would do that before making an ultimate decision on the sentence of death?
Yes.
No matter what you heard in the aggravating factors?
Correct.
So, under Florida law, first-degree murder usually means a premeditated, they thought about it, then they did it, killing of another human being. And often that person is an innocent human being. And in this case, you've already heard that that person was a law enforcement officer. You with me?
Yes.
Even if that really strikes at a chord of who you are, you would still be obligated to listen to the mitigating circumstances. Could you assure us that you would do that before making a decision?
Yes.
Any issue with that at all?
No.
You will never be asked to make a decision on the ultimate penalty of death before you listen to those mitigating circumstances. Does that make sense?
Yes, it does.
All right. I want to ask you a little bit about insanity, because it's potentially a defense in this case, as the judge told you. Because that's a defense, I need to ask you if you or anyone close to you has ever dealt with mental illness in their life.
I have a nephew that served overseas several times.
Okay. And so I take your response to mean that as a result of his service, he had some mental health issues arise.
Yes, he did.
Do you know if he ever got treatment for that?
Yes, he did.
To your knowledge, has that treatment helped?
Yes, it
has.
did.
Okay. So given your personal experience with your nephew and his mental illness, I'm assuming you believe that mental illness is real.
Oh, yes.
All right. I'm sure you can imagine that there are some people who think that it's not real and they dismiss it completely, but you're not one of those people.
No.
Okay. Again, if it were proven by the defense that Mr. Loyd had a mental illness and that because of his mental illness he didn't know that it was wrong, what he did was wrong, or the consequences of his actions, could you find him not guilty by reason of insanity?
Yes.
Even if that meant a lack of legal culpability for the crime, if it were proven to you?
If it were proven to me, yes.
All right. I don't have any other questions, Jonathan.
Thank you, Mr. Williams. Ms. Miller, you may inquire. For what? All right, let me see the attorneys at the bench.
Sorry. Just wanted to get your language. When Mr. Williams asked you your feelings on the death penalty, you said, if a person is proven to be guilty of murder, premeditated murder, they deserve to die. Correct?
That's correct.
Okay. And it sounds like, from how you said it, that's a deeply held belief that you have. Would that be fair?
Yes, it would be fair.
Okay. And
but
go ahead, I'm sorry.
Again, and I've said this several times, proof, facts, that's what happens here.
Yes, sir. And I'm certain you haven't sat around and thought about, like, how do I think about the death penalty? Right, is that fair?
That's correct.
But it does sound like you have some deep convictions about if somebody commits murder, he deserves to die.
Yes.
Okay. And so the first part of this trial, we call it the guilt or innocence phase, right? The state has to prove the defendant guilty beyond a reasonable doubt. Right? In a case where insanity is raised, the defense would have to prove by clear and convincing evidence the defendant is not guilty by reason of insanity. But if you decide the state has proven this defendant guilty beyond a reasonable doubt, and the state has not met it, or excuse me, the defense has not met its burden of not guilty by reason of insanity, right? You as a juror would be finding that defendant guilty of the intentional, premeditated killing of an innocent victim. Thought about it, meant to do it, and did it. Guilty. With me?
Yes.
So it sounds like once you've heard all the evidence and the proof, that for you, the appropriate penalty at that point is death.
If, as you say, the defense has not given any mitigating factors, then yes.
And I just want to be clear, mitigation is the second part of that trial.
Correct.
Right? That's why the defense, and mitigation doesn't have to just come from the defense's case in chief. It can come from anything. It's why anybody would choose life over death.
Correct.
Right? But so in deciding someone is guilty of premeditated intentional killing of an innocent victim, you would have determined that that defendant is guilty without any legal excuse, justification, or defense.
No, not the way you say it. If somebody has been proven guilty of murder and there were no extenuating circumstances, then yes, to me, the answer is the death penalty.
Okay. What do you mean by extenuating circumstances?
The obvious thing in my mind would be abused spouse, that type of thing.
Okay, so like if an abused spouse finally like snapped back and killed
Correct.
his or her husband
Correct.
or partner. Okay, so that's what, you know, sometimes the law calls that like heat of passion, duress, something like that. And so that's what I'm trying to lay out, is that if you have made the determination that the defendant is guilty of the crime of first-degree murder, there wouldn't be any of those type of extenuating circumstances that would be like, sorry, talking really fast, like a defense to the crime.
We object, asked and answered.
I'm going to sustain on that. I'm also going to intervene at this point. Sir, let me go over the process with you one more time, and then I'm going to let Ms. Miller continue with her questioning. In order to even get to a penalty phase, someone has to be convicted of first-degree premeditated murder, intentionally killing another person, all right? So I told you, Florida doesn't have an automatic death penalty. The penalty phase exists so that the state can present their aggravators, and they have to prove at least one beyond a reasonable doubt before you can even consider a death sentence. You understand that? You with me so far? All right. The defense, they present aggravators, which are, and they're limited to 16 by statute, reasons they believe death is the appropriate sentence. The defense is going to present mitigation. It can go to the defendant's character, background, circumstances of the offense, anything that can be used for you to make a decision. Those are reasons they believe that life without the possibility of parole is the appropriate sentence, all right? A juror has to be able to consider both of those with a completely open mind. You can't have made up your mind before you hear all of this. You follow me? Okay. So at the end of all that evidence, you're going to go back in the jury room, and I'll give you the jury instructions on how to do this, but you're going to weigh aggravators, mitigators. Weighing means you personally will assign whatever personal weight you give, what importance you give to the aggravators, what importance you give to the mitigators. You look at all of that, and then you make a decision. Now, even if, after looking at all of that, reading the instructions, everything, you say, well, you know, death is the appropriate sentence, you can still vote for life. Florida does not require a death penalty sentence from anybody, all right? So you can still vote for life. But if at the end of all of that, you felt that the appropriate sentence was life in prison, even though a person has been convicted of first-degree murder, intentionally killing someone, can you vote for life in prison?
Yes.
Okay. Do you have any doubt about that?
No.
Can you listen to all of this with an open mind?
Yes, I believe I can.
All right. So you would not automatically go back there and say, well, let me ask you, would you automatically go back there and say, look, he got convicted of first-degree murder. He intentionally murdered this person. I think death is the way we need to go without anything else. Okay. All right. Ms. Miller, you may proceed.
Well, tell me how you misinterpreted my question.
Well, you asked me if I believed in the death penalty, and then you said if somebody's found guilty, is that the answer? Well, again, I said the circumstances, and I'm talking about my circumstances, the circumstances I see, the facts I hear.
And I'm trying to have I don't want to put words in your mouth. So I'm trying to have a better understanding of what you mean by circumstances.
It's complicated. Okay, now we're talking presumably a guilty finding. Now, the circumstances that brought us to that, the facts that we heard, I'm sorry, I can't be more specific.
Okay. Well, let me say this. All of the law that the judge gave you is exactly right and applies if you are selected to be a juror in this case. Mm-hmm. The only oath you've taken thus far is to tell the truth. Correct. Right? And so I think everybody wants to feel like I can follow what the judge is telling me to do. Right? And that purpose of this questioning, because some people have stronger opinions about the death penalty one way or another. And you seem like someone who has a stronger opinion about the death penalty in favor of it. Right?
Well, I do. Like I said, it's complicated. I'll give you examples. Circumstances of families. The death penalty is something that drags on forever. It's the same as life imprisonment in some states.
Okay, and so are your feelings that the death penalty should be like handed down, the actual death part of it, the execution, more quickly?
Objection to the relevance of that question.
Not
Sustained.
really.
Hold on. Sustained.
I was just trying to understand what you meant.
Like I said, it's complicated. I don't have a black and white answer for you.
Well, and you say it's complicated, but it sounded pretty clear at the beginning. Your answer was, if you've committed premeditated murder, you deserve to die.
Objection asked and answered.
Sustained.
I didn't misquote you, correct?
No, you didn't.
Okay. And so then now the judge is asked, and the state is asked, can you follow these laws and consider these things, right? And I think you're a thoughtful person, that you're not going to ignore everything you've heard, right? But I'm asking you in your heart of hearts is, once you've decided somebody is guilty of the intentional premeditated killing of another person in an unjustified manner, if death is the only appropriate penalty for that person.
Objection asked and answered.
I don't think we have a clear answer given the back and forth.
Sustained. Let's move on.
When the court talks to you about mitigation, do you think you are someone who could consider the effects of racism on the defendant? And by that I mean, is it something that you would hear and it would potentially compel you to give a life verdict?
If you're asking me if I can consider somebody else being the subject of racism, I can.
Okay, and that's, again, I don't think you're going to sit there with your fingers in your ears and be like, la, 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 I'm not listening. I could tell you to go sit on I-4 in the middle of rush hour traffic, and you could say, sure, I'm going to consider it. You're not really going to consider it, right? The question is, when we talk about meaningful consideration, is it something that you would hear and it could possibly compel you to give a life sentence?
Objection.
Sustained. Rephrase that question.
Tell me what you mean when you say you could consider it.
It's easy for people to say, no, I don't, I'm not racist, or I don't see it, but it happens, and I see it.
I hear you. But is it something that you would give weight to in some capacity?
Objection.
Sustained.
There wasn't a ground for the objection.
Yes, there is. I know exactly what it is. Sustained. Rephrase the question.
When you say you believe it happens, tell me how that translates to, I would give that meaningful consideration.
Objection. Asking for weight.
I'm not.
Sustained.
What do you mean or do you understand my question when I say, could you give this meaningful consideration?
You're asking me if I can understand and accept the fact that racism plays a part in what happens?
And have some role in the verdict you reach?
Correct.
And do you think that it would?
Well, like I said, I see it, I understand it. I don't have blinders on.
Okay. How about the defendant having a tough childhood or tough background?
I would accept any fact or nugget of information in making a decision.
In making what decision?
Any decision. You're asking me like you want my answer now. I can't give you an answer. I mean, like I said earlier, you see TV or you read the internet, that's not fact.
True, I 100% agree with you, right? And it's tough because this is my only opportunity to speak with you, right? We may not even get to the second part of the trial in Mr. Loyd's case, excuse me, right? You may not believe the state's proven him guilty.
Correct.
Right? But the law requires that we have this conversation now because there's no other time if we get there. Right? And so I'm not asking you to render a verdict. I'm asking you to tell me what your feelings are, what your heart of heart is.
Okay. Like I said, I would take every nugget of information with an open mind. I mean, that's how you have to determine the facts.
And you would agree that it would be unlikely for 12 people to come to the same conclusion about all of this.
Objection,
Absolutely.
relevance.
Sustained.
If you are selected to be a juror, right, and you're in the deliberation room, sometimes things get contentious. People feel strongly. And you would not bully or badger anybody into changing their opinion just to agree with you, correct?
No.
And you're not going to allow anybody else to do that?
No, not to me, no.
May I have a moment, Your Honor?
You may. Come on up to the bench, folks. All right, sir. Sorry about that. I'm waiting. I said, all right, sir, sorry about that, while you were not sitting down. All right, sir, we're going to send you through for a final round of questioning. This is the final round of questioning, and at that point, we're going to pick the jury. So, a couple of things are going to happen. Number one, I'm changing your color to purple. As I told you, we use the colors to call jurors in. So you're now listening for the purple group. Don't expect a call before Wednesday at the earliest and potentially next week. I don't have enough people to call you all back in right now. Secondly, the jury would be sequestered that same day that we chose them, so you'll need to have packed a suitcase and brought it with you to the courthouse. Leave it in your car. If you need it, we'll go get it. If you don't need it, it'll be in your car. We're giving you a package with a slip which gives you the number to call, and we're also giving you a jury sequestration package which gives you a lot more information about being sequestered and gives you a list of things we suggest you bring with you. Do you have any questions?
No, ma'am.
All right, thank you so much for your time today. You have a great day. You're excused for now.
She needs that from you.